नमस्कार दोस्तों, हमारे शॉर्ट हैंड लैब प्रयागराज चैनल पे आप सबका बहुत बहुत स्वागत है। मैं आपको लीगल डिक्टेशन प्रोवाइड करने जा रहा हूँ, जिसकी स्पीड होगी 110 से 120 वर्ड के बीच में। 514 वर्ड की डिक्टेशन है। आप लोग अपने आप को डिक्टेशन के लिए रेडी कर लें। स्टार्ट। द क्रिमिनल कंप्लेंट अंडर सेक्शन 5 ब्रैकेट 4 ब्रैकेट क्लोज रीड विद सेक्शंस 5 ब्रैकेट 2 ब्रैकेट क्लोज एंड ब्रैकेट 3 ब्रैकेट क्लोज of the Official Secrets Act, 1923 bracket hereinafter called the Act bracket close was filed against the petitioner in the Court of Chief Metropolitan Magistrate, Delhi by the Union of India through Deputy Superintendent of Police, Central Bureau of Investigation, SPE, Anti-Corruption Unit, New Delhi, full stop. The petitioner filed an application under section 245 of the Code of Criminal Procedure in the trial court for being discharged on the grounds that the order of the prosecution had not been passed by an appropriate authority and that the cognizance could not have been taken as according to him, the complaint was barred by limitation, full stop. The magistrate rejected the application by his order dated 17/3/1995 and the revision filed in the High Court was dismissed, while the order impugned in this appeal, full stop. Relying on the provisions of section 13 bracket 3 bracket close of the Act, the trial magistrate as well as the High Court held that section 3 bracket 3 bracket close of the Act provided the taking of previous consent or sanction of the appropriate government and the time required for obtaining such consent or sanction was to be excluded in terms of section 470 bracket 3 bracket close of the Code of Criminal Procedure, full stop. It may be noticed at this stage that limitation in the instant case is stated to have started from 24th April, 1985 and the complaint was filed in the court on 9th May, 1988, apparently beyond 25 days of the period of limitation prescribed, full stop. The plea of the complainant was that period of 79 days required for obtaining the sanction order should be excluded in computing the period of limitation, full stop. Pointed out reference was made to the order of sanction dated 21st April, 1988, copy of which has been placed on the paper book of this appeal, full stop. Accepting the plea of the complainant, the complaint filed against the petitioner was held to be within time, full stop. Paragraph. Mr. Vijay Bahuguna, senior advocate appearing for the petitioner submitted that as no sanction or consent was provided to be taken from the government under section 13 bracket 3 bracket close of the Act, the complaint admittedly filed after the period of limitation was required to be dismissed and the accused discharged in terms of section 245 of the Code of Criminal Procedure, full stop. He did not urge any other point, full stop. In support of his contention, he has relied upon the judgment of this court in Electrical Manufacturing Co. Limited versus D.D. Bhargava, 1968 bracket 1 bracket close SCR 394, Sri Kirit N. Rawal, Learned Additional Solicitor General, defending the impugned judgment has submitted that the judgment relied upon his distinguishable as the mandate of section 13 bracket 3 bracket close is clear and unambiguous, providing the obtaining of sanction before filing the complaint, full stop. He drew our attention towards the averments made in the petition and the order of sanction to urge that even if no sanction was required, the complaint be deemed to have been filed within time as the complainant and the other officials bona fidely believed that such a sanction was necessary before the filing of the complaint, full stop. Thank you so much.